If you hold an H-1B visa, if you're studying on an F-1, if you have a green card, or you're waiting for one, the next few minutes could fundamentally change how you plan the next year of your life. Because what's coming in 2026 isn't speculation. It isn't rumor. These are confirmed regulatory shifts, proposed rule changes, and enforcement priorities that are already in motion. And the window to prepare is closing faster than most people realize. I'm not here to alarm you unnecessarily. I'm here because the people who understand what's happening will have time to act. And those who don't will find themselves reacting to situations they could have avoided entirely. Let's break down exactly what's changing, who's affected, and what you need to be doing right now. To understand why 2026 is shaping up to be a pivotal year, we need to look at where U.S. immigration policy stands today and where it's heading. Over the past several years, we've seen a pattern. Administrations introduce new rules, courts challenge them, agencies revise them. And through all of this, millions of people are left navigating a system that feels like it's constantly shifting beneath their feet. But 2026 is different. Several major regulatory timelines are converging simultaneously. We're seeing finalized rules that have survived legal challenges. We're seeing new proposed rules entering their comment periods. And we're seeing enforcement priorities that are being communicated not just through policy memos, but through actual agency behavior on the ground. What makes this moment particularly significant is that these changes touch nearly every major immigration category at once. We're not talking about isolated adjustments to one visa type. We're talking about systemic shifts that affect students, workers, families, and permanent residents in overlapping ways. And here's what many people don't realize. The immigration system operates on timelines that can stretch months or even years into the future. A decision you make today about whether to file a particular application, whether to travel, whether to change employers, that decision might not show its consequences until 2026 or beyond, which means the time to understand these changes isn't when they take effect. It's now. Let's start with the H-1B visa, because this is where some of the most consequential changes are taking shape. First, the registration system. If you've been through the H-1B lottery, you know how the current system works. Employers register beneficiaries, pay a small fee, and hope their name gets selected. But there have been serious concerns about fraud and abuse in this system. Multiple registrations for the same beneficiary. Companies submitting hundreds of registrations with no genuine job offers behind them. The Department of Homeland Security has finalized rules that fundamentally restructure how selection works. Starting with the fiscal year 2026 lottery, the selection process will be beneficiary-centric rather than registration-centric. This means the system will select unique individuals first, then allow employers to submit petitions. If your name appears in multiple registrations, you won't have multiple chances at selection. You'll have one chance, tied to your passport number and identity. This single change will dramatically reduce the number of total registrations in the system. Estimates suggest the pool could shrink by hundreds of thousands of entries. For legitimate applicants with genuine job offers, this actually improves your odds. For those who were relying on multiple submissions through different employers, that pathway is closing. But this is where many applicants go wrong. They assume that improved odds mean guaranteed selection. They stop preparing backup plans. They delay conversations with their employers about alternative visa options. And when selection day comes, they find themselves without a strategy. The second major H-1B change involves specialty occupation definitions. USCIS has been tightening its interpretation of what qualifies as a specialty occupation for years. But the regulatory framework is now being formalized in ways that will make these standards more consistent and more demanding. If your job duties don't clearly require a bachelor's degree in a specific field, if someone with a general business degree could theoretically perform your role, you may face increased scrutiny. This affects consulting companies particularly hard, but it's not limited to them. Even traditional employers are seeing requests for evidence that challenge whether the position truly requires specialized knowledge. The third change involves worksite inspections and employer compliance. The Department of Labor and USCIS are coordinating more actively on site visits. If you're working remotely, if your physical work location has changed since your petition was approved, if there's any discrepancy between what your petition says and what your actual job looks like, you need to be aware that verification is happening more frequently than ever before. I'll explain exactly what you should be documenting and discussing with your employer later in this video. For international students on F1 visas, the landscape is shifting in ways that will affect both your time in school and your transition to the workforce. Let's talk about OPT first, specifically STEM OPT. The 24-month STEM extension has been a critical bridge for graduates in science, technology, engineering, and mathematics fields. It provides time to gain experience, time to participate in the H1B lottery multiple times, and time to explore employer-sponsored green card options. But STEM OPT is not guaranteed to remain in its current form. There are ongoing legal challenges questioning whether the program was properly authorized through the regulatory process. There are policy discussions about whether it displaces American workers. And there are proposals to add new requirements for employer training plans, wage verification, and program oversight. What does this mean for you right now? If you're currently on STEM OPT, document everything. Keep records of your training plan, your evaluations, your employer's compliance with program requirements. If there are future changes to the program, having a clear record of your lawful participation protects you. If you're approaching the end of your initial OPT period and you're eligible for STEM OPT, file early. Don't wait until the last possible moment. Processing times fluctuate, and any delay in your extension approval could create gaps in your work authorization. Now let's talk about something that affects F1 students more broadly: unlawful presence calculations. This is an area where the rules have changed, been challenged, and changed again. Currently, students who violate their status may not begin accumulating unlawful presence until USCIS makes a formal finding or an immigration judge issues an order. But policy interpretations in this area are not static. If you're working more hours than your visa allows, if you're not enrolled full-time without proper authorization, if you've completed your program and you don't have a valid OPT application pending, you could be accumulating problems that won't become visible until you try to travel or apply for a different status. The students who navigate this successfully are the ones who treat their status like a legal document, not a formality. They know exactly when their I-20 expires. They know exactly what their work authorization allows. They keep copies of every approval notice, every employment authorization document, every communication with their designated school official. For those who already have green cards or are in the process of obtaining them, 2026 brings its own set of considerations. Let's start with travel and continuous residence. Your green card is a document that says you are a permanent resident of the United States. The word resident is doing significant work in that sentence. If you spend extended periods outside the country, you may face questions about whether you've abandoned your residence. The traditional guidance has been that trips under 6 months are generally fine, trips between 6 and 12 months may raise questions, and trips over 12 months can lead to abandonment findings. But here's what many green card holders don't realize. These aren't bright-line rules. They're factors in a totality analysis. An officer at the port of entry looks at the length of your trip, but also at where you pay taxes, where your family lives, where your property is, where your job is, how many times you've taken long trips in the past. The enforcement environment is becoming less forgiving of borderline cases. If you need to spend significant time abroad for family obligations or business reasons, you should be researching whether a re-entry permit makes sense for your situation. A re-entry permit is applied for before you leave the country and can protect your status for trips up to 2 years. For those in the green card application process, particularly employment-based applicants, the backlogs continue to be severe for certain countries of chargeability. If you were born in India or China and you're in the EB2 or EB3 category, your priority date may be years away from becoming current. This isn't new information, but what's changing is how people are responding to it. More applicants are exploring EB1 categories, which move faster but have higher evidentiary requirements. More are considering whether changing employers could affect their priority date portability. More are looking at whether their spouses might have an earlier priority date through their own employment, but I want to be very clear about something. Every individual's situation involves specific facts that affect which options are available. What works for one person may not work for another. The goal right now isn't to make immediate decisions. It's to understand your current position clearly enough that when the time comes to act, you're not starting from zero. Now, I want to pause here and acknowledge something that doesn't get said often enough in videos like this. The immigration process is not just a legal process. It's an emotional one. You're making decisions about where to live, where to work, whether to start a family, whether to buy a home, all while knowing that a single policy change or processing delay could upend everything. That stress is real, and it doesn't help when you're constantly hearing about worst-case scenarios without any clear guidance on what you can actually control. So here's what I want you to take from this section. The changes coming in 2026 are significant, but they are not unknowable. They're not random. They follow patterns. They get announced through official channels. And the people who stay informed, who build relationships with qualified immigration professionals, who keep their documents organized and their timelines clear, those people navigate these changes successfully. The people who struggle are the ones who try to ignore immigration issues until they become emergencies, who rely on outdated information from friends or online forums, who assume that because something worked for someone else, it will work the same way for them. Later in this video, I'm going to walk through specific steps you can take in the next 30 days to assess your situation and identify where you might have vulnerabilities. But first, let's look at who is most affected by what's coming. The changes we've discussed don't affect everyone equally. Let's break down who faces the highest stakes. H1B workers at consulting companies and staffing agencies face increased scrutiny under the new specialty occupation standards and third-party worksite rules. If you work at a client location rather than your employer's own office, your petition is more likely to receive a request for evidence. Your employer needs to be prepared to document the nature of your work, the duration of your assignment, and the specialized knowledge required. F1 students in the final year of STEM OPT face uncertainty about program continuity. While there's no indication that current participants will lose their status, any future regulatory changes could affect extension availability. If you're planning to rely on multiple H1B lottery attempts during your STEM opt period, understand that this strategy has risk built into it. Green card holders with jobs or family obligations that require extended international travel face increased abandonment risk. The more time you spend outside the United States, the more important it becomes to document your ties to this country and to understand the re-entry permit process. Employment-based green card applicants from backlogged countries face continued uncertainty about whether they will be able to maintain status long enough for their priority dates to become current. Job changes, company closures, and visa status expirations all create pressure points that require careful planning. And finally, mixed status families, where some members are citizens, some are permanent residents, and some are on temporary visas, face complex decisions about timing. When should you file for adjustment of status? When is it safe to travel? What happens if a visa expires before a green card is approved? These questions don't have universal answers, but they have answers specific to each family situation. The common thread across all of these groups is that waiting to address potential problems almost always makes them harder to solve. Immigration cases have timelines, filing deadlines, and procedural requirements that don't pause for personal circumstances. So, what should you actually be doing right now? Let me walk through a framework for assessing your situation. First, know your status and your deadlines. This sounds basic, but you would be surprised how many people cannot immediately answer the question. When does your current authorized stay expire? When does your work authorization expire? When does your visa stamp expire? These are different things, and confusing them creates problems. Pull out your I-94 record. You can find it online at the CBP I-94 website. Look at the date you were admitted and the status you were admitted in. Pull out your EAD card if you have one. Check the expiration date. Pull out your visa stamp if you have one. Check that expiration date too, but remember that the stamp only affects your ability to enter the country, not your authorized stay once you're here. Second, create a timeline of upcoming events that could affect your status. Are you changing jobs? Are you finishing a degree? Are you traveling internationally? Are you getting married? Is your employer being acquired by another company? Each of these events can have immigration consequences, and knowing about them in advance gives you time to prepare. Third, organize your documentation. Every approval notice you've ever received, every EAD card, every I-20 or DS-2019, every entry stamp in your passport, every job offer letter, every pay stub. Keep digital copies in a secure location. Keep physical copies in a folder you can access immediately if needed. Fourth, identify questions you cannot answer with certainty. If you're not sure whether your current job duties match what was described in your visa petition, that's a question. If you're not sure whether your spouse's pending application affects your travel plans, that's a question. If you're not sure how long you can stay outside the country without risking your green card, that's a question. Write these questions down. These are the conversations you need to have with someone qualified to review your specific situation. Fifth, and this is important, do not rely solely on information from unofficial sources. Online forums, social media groups, even well-meaning friends who went through a similar process can give you information that is outdated, incomplete, or simply wrong for your circumstances. Immigration law is highly fact-specific. What worked for someone else may not apply to you at all. I'm not providing legal advice in this video. I'm providing awareness. The difference matters. Awareness tells you what questions to ask. Legal advice tells you what to do based on your specific facts. You need both. Let's bring this together with the key points you need to remember. First, the H1B lottery is becoming beneficiary-centric for fiscal year 2026, which reduces the total number of registrations, but improves odds for legitimate applicants with single registrations. If you're relying on multiple submissions through different employers, that strategy is ending. Second, F1 students and OPT participants should be treating their status documentation with extreme care. Keep records of everything. File extensions early, and understand that STEM OPT, while currently available, faces ongoing legal and policy scrutiny. Third, green card holders who travel internationally need to be conscious of how their travel patterns might appear to immigration officers. Extended trips abroad, especially recurring ones, increase abandonment risk. Re-entry permits exist for a reason. Fourth, and most broadly, the people who successfully navigate these changes are the ones who stay informed, stay organized, and seek qualified guidance when they face questions they cannot answer on their own. Immigration policy will continue to evolve. New proposals will be announced. Rules will be challenged in court. Processing times will fluctuate. None of us can control these external factors, but we can control how prepared we are to respond to them. If this video helped clarify what's coming in 2026, subscribe to this channel. New updates are coming regularly as the regulatory landscape continues to shift. And in the next video, I'll be breaking down specific scenarios involving job changes during pending green card applications, including what triggers a problem and what doesn't. Until then, stay informed, stay prepared, and take the time to understand your own situation before 2026 arrives.